you're getting two moderators for this discussion since it's the last one of the day. And this problem, as you can see, the cultural resistance to innovation. I think all the lawyers who look at that get a collective duh. I mean, we are a profession that's based on precedent. We're a profession that's based on looking at what a court decided 75 years ago and whether it's still good law. And if it is, by gum, we're going to stick with it. So now you've got a profession that's being asked to reinvent itself in light of the fact that the world has changed. So that's what this panel is going to discuss. You can see we've got a larger panel than normal. We've got 5, some of whom you've already heard from, Bill Dunn and Elizabeth Silverman. Erika Davis is in the back. Chris Hastings you've heard from already, and Jerome Crawford. Julie, I don't know if you want to ask the first question or throw it to me or what you want to do.
Absolutely. Let me get the microphone. I'll start with the first question. We've got a great panel here. This is a question for Bill. Just as you're getting situated, here you go. I'm testing your ability to multitask. The ABA task force recommended establishing regulatory objectives. Are they important to regulating the evolution of the profession? Are we on the right track?
Yes and no. First of all, it is an absolutely essential part of the process that we understand why we are regulating anything in order to determine what should then be regulated. As we talked a few minutes ago and has pervaded the panels, that the regulation of lawyers is not to protect the prerogatives of the legal profession, but to promote service to the public. And that is stated in rules around the world, Canada, Australia, US, and so forth. So we have to figure out what is the purpose of regulation, what is it serving? Is it just to keep the profession in line? Is it to protect against innovation and competition? Is it to motivate the profession to perform? Just what are we trying to do? So if the functions of regulation are clear in our minds, then we are then directed about what they should look like. The regulatory objective proposal of the ABA task force it was inspired by work of others. The UK, New South Wales all have regulatory objectives, and the ones produced by the ABA differ from those in some respects. For example, the UK regulatory objective encourages competition with lawyers. That's not in the ABA version, but should it be considered? And of course, that tends to fall out in licensing legal service providers that are not admitted lawyers. So regulatory objectives is a very healthy exercise. Exactly the ones that were proposed by the ABA task force, and I guess to be in front of the House of Delegates for some discussion at this meeting in a couple of weeks, have been opposed because while they have been described as motherhood and apple pie, and indeed you could read any worthy cause out of any of these stated objectives, what underlies them is identify and implement regulatory innovations related to legal services beyond the traditional regulation of the legal profession. And you can imagine how that invokes reaction of the legal profession. So it's a large task to identify or to get buy-in to regulatory objectives that can encompass a broad range of service providers. I think that lawyer regulation is too narrow a subject for us to be looking at this point. I would advocate creation of regulations and regulatory objectives to match that would serve whoever provides legal services. And whether that's the same as practice of law, is debatable. I don't think it is. I think it's far broader than the practice of law. Lastly, these regulatory objectives may help us find a way to regulate non-admitted lawyer legal service providers other than through the device of unauthorized practice of law, which is a very negative process and of course involves what is the practice of law, another topic.
And just a warning for the audience, with this last topics, it's sort of a catch-all, so we're going to be bouncing around a lot. There may not be as smooth a segue between questions as you've seen in the past. And also, because I know I'm going to hear from some of my friends who are members of the ABA litigation section, to be clear, the task force recommendations do not include verbatim the regulatory objectives of the ABA. We're still discussing what regulatory objectives we might consider if we were to adopt regulatory objectives. Moving on now. Jerome, I'm going to throw it back your way. We've had some discussions about ready to practice, law students, young attorneys. What modifications would you suggest as somebody who is a newer attorney to law school curriculum that you'd find useful to better address 21st century practice?
Sure. So speaking to those modifications, and I see my law school dean here, Dean Howarth, and so she knows my, I'll call it radical nature and radical outlook I've always had on legal education. For starters, I think that, you know, the common comparison between lawyers in their professional career is doctors, right? And we've seen that thrown around a lot of times up here today. But one area that, frankly, the legal profession has been lacking in is the term I call apprenticeship. There's no period similar to residency where there's a requirement, if you will, that you have to go through a certain period of time or number of years to, frankly, before you let a surgeon come and start cutting on you, you'd like to know that they did some apprenticeship. I mean, how would you like to know? Your doctors have not done residency. So making that same comparison to the legal field, I think that many clients would probably be troubled to know, oh, you don't know what a precipice is? You just figured that out? Okay. I didn't know you didn't know what motions were and how to prepare them and how to do things in court until after you've taken the bar and actually become licensed. So to the modifications point, I would think that requiring clinics, right, the same way that we have made other requirements for our doctrinal courses in those early years. I love hearing some of the radical ideas about maybe an earlier administered bar exam, that sort of thing. In our work group, what came up a lot was the modification of particularly the third year. So if we made the third year of law school but just truly a full apprenticeship year, essentially the law student's residency period, or there was even talk about blending that to some degree, where in every semester you're required to do a certain number of credits that are clinical-based, externship-based, frankly, experiential and skills-building-based type courses or experiences. So that would be the primary modifications I think I would suggest, is that we need to get lawyers being more hands-on, because one anecdote I'll note is that I think we heard the comments about business sort of feeling as if it's invading our space, and business is taking things over and they're coming into the lawyer zone. Well, if we don't do it, they will. And that should be a very, very, sobering point, but one I think should be inspiring to our own entrepreneurial nature as attorneys and what we can do to meet the change, because our clients are getting savvier, and if we don't adapt to the change, they certainly will.
Question in regard to, as a follow-up to Judge Hicks. He was asking that we look at this issue about the billable hour. And so my question, I'll start with Erika to answer it, and if you can keep your answer as succinct as possible, maybe Elizabeth wants to weigh in. What is your take with regard to alternative fee arrangements? Should lawyers engage in it? And because many people here think that somebody is going to get slighted in an alternative fee arrangement, and it might be the lawyer, do you think that alternative fee arrangements spell doom for the profitability of a lawyer?
No, I don't believe alternative fee arrangements spell doom for the profitability of lawyers. And I do believe that we should be open to exploring it. One of the reasons I believe we resist certain types of change is that we don't know what the alternative would look like. or how it would work in real time and in real life. So I believe that it's very important as we move forward, and I think that the bar can take a strong leadership role in that regard, is through educating our members about ways of billing for our services that both recognize the value that we bring to the table, because I strongly believe that LegalZoom and the other disruptors in the marketplace do not replace our professional skill and judgment as individual lawyers, but that we need some more guidance and information on how that looks. And I think the State Bar can help us with that by providing some more education concerning alternative fee arrangements and creating a space where we can address it. I also think that we may need to look at our regulatory framework, because the other bit of resistance is a real concern about the fact that we think that we may think that a fee, an alternative fee arrangement, is reasonable, and our client may think it is, but our regulatory bodies may not agree. So I do think that there is some room for change, and there is a possibility to create a framework where we can protect the public and also make a living as lawyers.
And basically, I think that there's some aspects of law that are already doing that. When I had people come to me and wanted me to do wills and trusts, my initial reaction when they said how much would it cost depended on how much time I spend on it. And you could just see the look on their face drop. You know, does that mean thousands of dollars? And so I think everybody who does wills and trusts will give a flat fee. And for some clients, you make more profit because they're very easygoing. Other clients are going to bombard you with phone calls and multiple changes. And I think you do just have to learn how to adapt. But I don't think that we learn inside the profession or inside law school how to do that. So I do think we need more guidance.
Bruce, looks like we have some questions.
Okay, before we have the questions, I will just take the privilege of pointing out there is a sweet little bit of irony in having Erika Davis talk about engagement agreements, because she just got engaged, so congratulations. Now, let's go. We've got some questions from the audience. Please identify yourself so the virtual participants will know who you are.
This is, This is Patrick Ellis with the task force. Sorry for the echo. Okay, that's better. Or maybe not. What role should the bar play in addressing, there's been a lot of conversations about upstarts, startups in the profession, or coming from the outside and taking work that's been traditionally done by lawyers and sort of segmenting it or commoditizing it. What role should the bar play in addressing these innovative companies or startups?
That's a great question. Bruce, you may have wanted to offer somebody to answer it, but one other thought is, as an add-on, if anybody would like, should the bar engage in a definition of the practice of law that is adopted and might bear on this? Maybe you were about to mention that, Bruce.
No, I was going to throw it open for whoever might want to address it.
I'm happy to jump into that fray. Okay.
Well, I did answer that question already, Julie, and these poor people have heard plenty from me. Should we define the practice of law? Absolutely. What role should we have in engaging the marketplace as new people come in? At a very minimum, we need to understand how the market's changing, and we need to participate in the re-regulation of the marketplace. We are, as a community of lawyers, very welcoming of some kinds of change and very resistant to other kinds of change. And the kinds of change that we resist are professional change. We spend a career learning how to make money, and we finally think we've got it, and then somebody tells us we need to do it differently, and we go, no, we don't want to do it differently. It's coming, and we have to be aware of it, and we have to be ahead of it, and we have to engage it.
Bill.
Definition of the practice of law has been defined, it's been created virtually in every state. Most of them are different. Legislatures have chimed in to reflect public dissatisfaction with the lawyers' definitions of it and define things that weren't the practice of law. The problem with a definition is it tends to be overbroad and it tends to protect the profession. And indeed, the Michigan proposal that was once submitted starts off with a purpose statement to protect the public from persons engaged in UPL. Okay, not to define what is the practice of law, but to protect the public against persons engaged. Now, there are other approaches to this, and by the way, the North Carolina dental case of the Supreme Court casts a pretty large doubt on the ability of the profession to create its definition when that definition could be overly broad. And when the ABA attempted to create a definition some years back, in the early 2000s, the FTC and the Department of Justice warned that this could easily be violating antitrust laws. These are cautions that we need to consider in saying we can dictate and determine our fate against people who aren't admitted to practice law by the Supreme Court. There are other ways of going about it. Departing from a lawyer-centered perspective, we can look at a creation of a practice of law definition by defining what activities involve enough risk to the public that they could only be done by lawyers, and what can then be done by non-admitted lawyers. This is a process that we ought to try to engage in rather than defining people out of the system. We ought to define what are the risks in client or in consumer needs to be met, and how can they be met most efficiently and practically by whomever the legal service provider is.
Can I just add one word to that, to answer that question directly would be education. I think that's the role the bar plays, is educating the public.
Right.
We have to engage the public and help. So to take just what my colleague just mentioned a moment ago, once, if or when we're able to reach these definitions of what they are, and I'm sure they'll be fluid and change over time as the marketplace changes, help educate the public. So the public's going to make the decision, right? They're going to make the decision, do I go to a lawyer, quote, or a quote-unquote non-lawyer for this service, and what do I need? So I think as they're more educated, they're getting savvier anyways, let's help meet them where they are.
Throw this open for the panel. One of the considerations in the task force was the Justice Innovations Center and the Rolls Bar. The Rolls Bar? How about the bar's role in the Justice Innovation Center, which would be sort of an ongoing think tank to address the ever-changing profession? I'd like your opinions quickly because we do have a question waiting in the audience. Throw it open for anybody.
I got to tell you, I think that we underutilize the bar, but I think that when you open yourself up to the ideas, I can't imagine a downside to it.
Looks like we're getting a lot of nodding heads, so let's throw it open to the questioner.
My name is Laura Kubit, and I love the idea of a formalized apprenticeship either while you're in law school or shortly thereafter, but how do we find the right balance in creating value for all involved? I know as a law student, I was frustrated by taking an internship or externship class where there was very limited direction, and I was essentially paying tuition to work for free versus, so how are we ensuring that there is formal guidance to the students while they're paying tuition? And then if they're working for a private employer, how do we make sure that that employer's bottom line of a profit is ensured while still making sure that that person is truly educated?
Throw it open. Chris?
I have a very personal answer to that, since I'm a law school professor in Grand Rapids. After practicing law in Grand Rapids, litigation practice for 20 years, and knowing Grand Rapids lawyers, such as Mr. Courtade here, and it's a process of working with the student to identify the students' goals, and then matching students with sites and lawyers who can and are willing to mentor, and helping see them every step of the way so that they can get what they need and are introduced to something that'll be a very rich professional experience for them, and also be an experience for the site, the place that's getting the extern, to be excited about taking more externs. So it's just a lot of work at the grassroots level.
If I could narrow it down by two aspects, I think that students, if we're going to begin this standardization process where we require a certain amount of credits or investment per student in their law school education to ensure they're, quote, practice ready, I think it would be twofold. First, it would be some sort of experiential, again, opportunity. I think we have to keep it somewhat broad, because when we get too specific, then given the various areas you can go into with your law degree, maybe we're pigeonholing folks too much. That's why I've seen law schools now, frankly, start to repeal and pull back their required courses, where I think when I was a 3L, for instance, MSU Law, evidence no longer a required course. And some people say, oh, that's crazy, it's on the bar. Well, you have folks who say, I'm never going to use it other than the bar exam. So I think we have to keep it somewhat broad on what that experience is, but that the standard be that it be a certain amount of credits. And to your point, I understand it can be difficult. I'm paying these credits, and if I'm paying to work for free, maybe it's not a meaningful opportunity, but that comes, I think, in the investigation phase of finding a good fit. The second portion of that, what the student needs to obtain, I believe, will propose some sort of law practice management skills. So learning how to be more entrepreneurial, and we need to empower our students today, and from a legal education standpoint, because that traditional model, I don't want to just say it's gone, but that's how I believe it is. And I work in a quote-unquote big law firm, but I understand how rare that opportunity is and how more rare it's becoming as we move forward. So if our students are empowered to be more entrepreneurial, where we can create more, Burt Whiteheads of the world that are getting out there and showing I can make my own practice because there is opportunity. I don't believe there are too many lawyers. We just have to show our students, and soon to be lawyers, how to find them.
We've got 2 minutes, Bruce. Do we have time for another question from our panel?
I think I'd throw it back to the panel using my closing question for the different groups I've had. One thing that jumped out at you, got you excited, that hopefully hasn't already been discussed today. Start with Bill. You're next to me. Keep it short, please.
The opportunity, as I mentioned before, of this exercise.
Basically, I love that there's a task force that's going to try and revamp on a broad basis. One of my pet peeves is the fact that although I email everything and scan everything, I have lawyers that I will call and say, it's 7 days before the hearing, do I have to hand file a motion to you? Can I just email it? And some of the lawyers go, oh, my law firm won't let you email it, which is fine. I'll jump in a car, I'll send my secretary, to do it. But the rules are very, very antiquated in some ways. You have to have permission of the other side to be able to email them, which is kind of crazy, if they have email. It reminds me that in the past, when there was just faxes, certain lawyers would unplug their fax machine. I mean, just silly stuff. So I like the fact that we're trying to focus on a broad range of what can we do to make it more efficient.
Erika.
What really jumped out at me about this whole process and conversation is just how wide open the field is and how numerous the opportunities are. One thing I wanted to quickly share, because it overlaps with some of the other panels we talked about before, and that is efficiencies within certain legal processes. I am an arbitrator with the American Arbitration Association, and so in some ways, I am a quote-unquote judge, but with AAA's processes is a procedure that allows me to manage cases and the user's needs virtually without seeing them until the date of the hearing. We handle our preliminary conferences by phone. We resolve issues by phone. Everything gets sent to me via email. And then if there's an in-person hearing, then they have their day, their time, and their opportunity to come and see me. I know that that's probably a radical and revolutionary approach to take system-wide, but I think looking at other fields and other industries and areas may help us navigate and decide what would work best for us in the state of Michigan.
Chris.
Picking up on what William said and what Erika said, being involved in this process has just been so much fun because everybody is engaged and everybody has ideas, and it's like being in a room with 1,000 ping pong balls just bouncing all around, all the different ideas and stuff. So I guess my parting thought is I'm glad I'm a lawyer, and God bless us, everyone.
Jerome.
Briefly, my parting thought comes from former President William Hubbard of the ABA. When I attended an ABA meeting about a year ago, I'll never forget him making a comment, because that year, that was one of his pushes, the future of legal services. And I'm glad to see Michigan having taken that call and standing at the forefront, because he made a comment and how it's coming true when he said, you know, the amount of people that own smartphones, I think he said it was around 87%, I believe, of folks that are below the poverty line own a smartphone. And he said, well, what if that person who came home, because of the strong likelihood that they might, in their circumstances, come home and see an eviction notice on the door, if they could take a picture of that, take a screenshot, and send it into an attorney or some service or some advocate and be able to get help. Now, he was speaking about a what if, and this is just about a year ago. Well, about 2 weeks ago, I was watching Shark Tank, and I forget the exact name of the product, but it's for parking tickets, and specifically in the state of California, how folks get parking tickets. They take a picture of the ticket, say, I sent it to an advocate. They call them their advocates. These are probably just lay people that have done a little research about the law and parking tickets, and if you challenge them, you got a good chance of winning, where you say your parking ticket's $55, whatever it is, and if they win, you pay a processing fee for you. And of course, if they lose, then there's just like if they win, you pay a percentage of the parking ticket, 35% of the parking ticket. If they lose, you pay a processing fee. Now, these are folks that are non-lawyers that have already, just about a year ago, something that the ABA president has already said, what if? This is happening. So I'm happy to see Michigan at the forefront of this charge and know that we need to continue the push. I'm glad to see what we've done this year, and I'm excited about the next steps, because there's more change to come.
Okay. Well, we have reached 3:48, and I am happy to tell you that the agenda that I got before we started said that we should be here at 3:45, so we've actually made up time. Our work today is wrapping to a close. That was the final session. We will be sticking around for a few minutes, but the work of the task force and the work of the state bar is far from done. Your feedback today will be taken back to the task force. Many of its members are here. Many of its members have been listening virtually, and we will be compiling a final report to go to the Board of Commissioners in March. We encourage your continued help and feedback on any issues that you may have heard about today that you want further discussion. The list of the task force members is available on the State Bar website. Julie and I have our contact information all over the place, so please feel free to contact us at any time.
We've come into this with an open mind. We continue to have an open mind, and even though the work is just beginning the wrap-up stage, I think that the opportunity is still there for those of you who have been listening in, have realized that there are issues that you have opinions on, but you didn't get a chance to offer a question on it. The opportunity is there for you to contact us. We'll listen, and you may very well help drive what we end up producing later on in the year.
I'd like to thank all of the State Bar staff once again, and Janet Welsh for all the tremendous work that they've done pulling this event together. You have no idea some of the backstage things that had to be done. I'd like to thank those task force members who agreed to serve as panelists today, and those who came without serving on a panel to sit today and hear what was going on. Thank you for that. Thank you to the committee members. I know that Scott Bassett and Victoria Vuletich are task force members who are appearing virtually, so thank you to you two for continuing to push us along the technological frontiers. And Jeff Barker, I know you spoke earlier. Where's Jeff again? Thank you again for your work, and thank you for helping us to secure the technology that we needed to pull this off. Without anything further on my end, thank you all for coming, and Godspeed.